বাচ্চা ছিল না, এডিটিও আছে। Section 3, certified exception 2. The matrimonial relationship between men and women stands on a different pedestal than any other relationship, and the disputes arising out of matrimonial relationships are aptly taken care of by the current laws of the land. Hence, it is humbly contended that there is no violation of Article 14 of the Constitution of Imata. Integer. Much obliged to your lecture. Much obliged to your lecture. The council for clearness and purpose. Much obliged to your lecture. The council seeks permission to continue the arguments. Much obliged to you. The marital rape exception is not violative of Article 15 subclass 1 of the Constitution of Imata. It is humbly contended that the council for the respondent said that marital rape exception is not violative of Article 15 of the Constitution of Imata. Article 15 states about discrimination on the basis of caste, sex, color, creed, religion. In the case, there is no such discrimination in Section 375 of Imatan Penal Code. A male or a female or a transgender or an animal or a human being all have been given recognition in the eye of law, protected by laws, bylaws, and statutory regulations. Section 375 shows the classification between married women and others, but the classification will not come under the discrimination under Article 15 as if there is no discrimination between men and women. The marital rape exemption is not Lordship. The council seeks permission for extra time as the time ends, Lordship. May I continue, Lordship? Much obliged to you, Lordship. The council seeks permission to submit the prayer, Your Lordships. Much obliged to you, Lordships. Therefore, in the lights issued, arguments advanced, and authorities cited, the respondent respectfully request the Honorable Supreme Court to adjudge and to be pleased to not consider the live-in relationship as marriage, and marital rape may not be brought under the live-in relationship, not to validate the implementation of election manifesto as constitutional, not to validate the criminalization of rape. The Honorable Court may pass order as deemed to be fit in the interest of justice, equality, and good conscience. Much appreciated.
The council seeks permission to rebut the opponent council's arguments. The learned opposite councils for the petitioner had argued that stating that live-in relationship considering as a marriage and considering marital rape under the purview of live-in relationship could destroy the cultural value of this conservative Immigrant society. In order to rebut that, to quote that, in Payal Sharma versus Nari Niketan case in 2002, the Supreme Court expressed that even the live-in relationship are recognized as immoral by the society, it is neither illegal or offense under the eye of law. By democracy, there is a difference between law and morality. And moving on to the policies, stating that policies of a government, policies in by an election manifesto should not be biased, which would be rebutting in Article 15 of subclass 3, stating that the state can make any law making a special provision for women and children, which is a positive discrimination, and it can be biased. And in regarding the marital rape exception, states that the exception does not violate any article, the 14, 15, 19, 1, class 1 of subclass A and Article 21. But the marital rape exception in section 375 violates Article 14 as indeed, Your Lordship, during the time of marriage, the wife gives her consent to marry a man and to perform a sexual intercourse, Your Lordship. At the time of marriage, a man, he has a reason to believe that she gave her consent. Later on, the consent can become hostile to Your Lordship. So under this, his right is being violated, and he'll be at any time, he'll be so. Indeed, Your Lordship, in exception to there is no ingredients relating consent, Your Lordship. But rape in section 375 they mentioned about consent. But exception 2 is without consent. There is no term called consent, Your Lordship. There is no definition for that term in that particular exception, Your Lordship. Indeed, Your Lordship. There is lack of intelligible differentia of the repeal of MRE, and equal treatment for equals and unequal treatment for unequals is the main motto here in this repealing of this particular section, Your Lordship. Second, Article 19, Clause 1, Subclause A of the Constitution is also being violated, Your Lordship. Men cannot exercise his conjugal rights and he cannot express his sexual requirements to his legally wedded wife, Your Lordship. Third, Article 21 of the Constitution is
between the women itself, my lordship, cause the equality between the married and unmarried women hinders there. That's all, my lordship. It's the men gets affected the way a little bit. My lordship. Express women, my lordship.
authenticity with the statement of a wife as there is a possibility to turn hostile, Your Lordship. In this situation, because of this, dignity does not come to a man if he is compelled to remain in the state of constant fear. We are of the considered view that it is the obligation of the state government to see that appropriate and effective steps are taken to protect the citizen from such a capitalism and to make arrangements.
Yes, the women has to be given equality and there shouldn't be any discrimination. That is what I'm saying. If it has been repealed, then men will be discriminated. And as I said before, the section 498A, they have been affected by 498A. If they repeal section 375 exception, and the men will be affected again. And there are more laws which has been supporting for the women, whereas for men there are no laws which has been supporting the men. Indeed, Lordship.
Case Abhinaya is considered as a major, Your Lordship. Hence, Your Lordship, marital rape exception is the legitimate immunity provided under IPC. In fact, Your Lordship, the denial of indeed, Your Lordship, but the situation, if it so happens, it will, most of the married men would put behind bars for exercising their legitimate right, Your Lordship. And he has a right to express his own sexual desire to his wife. Yes, indeed, Your Lordship. Yes, Your Lordship. They can file under Domestic Violence Act and under Section 498 of URC. This is what we want to come to the ground now. We are going to argument. The simple argument.
Don't understand what will that structure. How long I can wait for the compound?
Indeed, Your Lordship. Hence, it is humbly pleaded before this honorable bench that cabinet resolution to introduce the bill of MRE should not be repealed since it is hence it is constitutionally invalid, Your Lordship. And the council seeks permission to move on with the next issue. Much obliged, Your Lordship. Whether the criminalization of marital rape is constitutionally valid. It is humbly submitted before this honorable bench that criminalization of marital rape is constitutionally invalid, Your Lordship. Marital rape envisaged in exception 2 of section 375 IPC provides immunity to husband against sexual allegation of having sexual intercourse with his own wife who is not less than the age of 18, Your Lordship. Here, Abhinaya and Karthik were still in... Much obliged, Your Lordship. Here, Abhinaya and Karthik was still in relationship of marriage and they were not even judicially separated. The act of Karthik will not even fall under section 376B of IPC. The marital relationship is the communion of two individuals, which includes mutual obligation, companionship, sexual relation, and exclusive enjoyment, procreation, etc., Your Lordship. MRE has made clear and accepted the differentiation between rapist, separated husband, and a married man based on the consent factor, Your Lordship. When a man has raped a woman not being his wife, will be punished under section 375 of IPC. If being his wife but not below 18 years, he has exception under section 375 of IPC. When a separated husband on the basis of degree of court will be punished under section 376B. In that case, there is a breakage of emotional and physical connect between them, Your Lordship. But when a husband has marital coitus with his wife, he would not attract any penal remedies. Through the state has balance between the rights of a married man against the rapist, Your Lordship. In criminalization of marital rape, that legitimate differentiation lacks and treats all men equally. Also, right to privacy of husband has right to safeguard the privacy of his own marriage, and it is an encroachment of his privacy, Your Lordship. When moving on to the practical difficulty of the criminalization, it does not observe principle of natural justice and ambiguity over consent, Your Lordship. Section 114A of Indian Evidence Act generally says when the prosecutrix states that she had not given consent to the sexual intercourse, it must be shall presumed by court, Your Lordship. But in case of marriage, as there is an existence of mutual understanding, emotional and physical connect, the husband has reason to believe that his wife has given consent, Your Lordship.
Then he doesn't create a comfort space, that comfort space is the family. And often it is criminalized.
Indeed, Your Lordship, it cannot be criminalized. Indeed, Your Lordship. The consent has been given within private space of 4 walls, Your Lordship, and it will definitely give rise to hostility. So, repeal of MRE would give rise to new offence, Your Lordship. Hence, it cannot be criminalized, Your Lordship. Hence, it is humbly pleaded before this honorable bench that marital rape exception in upholding the rights provided under Part 3 of the Constitution, and the Council is seeking the Honorable Supreme Court to uphold the same, Your Lordship. The Council seeks permission to move on with the prayer, Your Lordship. Therefore, in the lights of facts stated, issues rise, arguments advance, and authority cited, it is humbly prayed to this Honorable Supreme Court of Imada to be graciously pleased to uphold and declare live-in relationship or not marriages. Hence, marital rape can be invoked in the live-in relationship.
to direct not to entertain the complaint of the prosecutrix petitioner under marital rape and to provide alternate relief to the petitioner, to affirm election manifesto by government of Travis as violating fundamental rights of married women, to endorse criminalization of marital rape is constitutionally invalid. Court may pass any order, direction, or relief that is honorable Supreme Court may deem fit in the interest of justice, equality, and good conscience, Your Lordship. Much obliged, Your Lordship.
Entire memorial consists only of arguments and not backed by any empirical data or any statute or judicial pronouncement. Basically, the entire, or it is basically a debate, Your Lordship. This is not a parliament to enter into a debate. There has to be a judicial pronouncement, there has to be a proposition, Your Lordship.